Okay, I guess we'll call this meeting of the Community and Economic Development Committee to order. It is Thursday, September 1st, 2022. And we'll do some introductions. I'm the chair, Pete Peterson.
Christopher Constant.
Kevin Cross.
And those who are on the phone,
Felix Rivera.
Mr. Rivera, anyone else on the phone? All right, maybe they'll join us shortly.
So that creates a quorum.
We have a quorum. Fantastic. All right, let's go to new business then, and we'll have a discussion of AO 2021-88. Mr. Constant.
Thank you. I would like to add a third item under new business,
Okay.
and that is just the initial discussions on shifting the licensing structure for marijuana licenses from 1 year to 2 years.
Okay.
I'll probably need 5 minutes or less.
Okay. All right, we can start a discussion on that. Okay. Anybody here to that has a presentation of from the building board or want to discuss this? If you're here from the building board, raise your hand. Do you have any information you'd like to present to us today about the memo we got from you about making some changes to some amendments we made last year?
I think the intention of us being here is just to see what your opinion is on the letter that Keith sent regarding the exemptions that were amended at the last meeting and basically the potential ramifications from that, to see if the assembly themselves actually agree with our proposal of going back to the original wording versus the amended as is.
Mr. Chair, could we identify who these folks are?
Oh, yes, we should. Yeah, introduce yourself, please.
Yeah, I'm Dan Benoit, the building board as vice chair.
Okay. And you're...
I'm Craig Fredine. I'm a mechanical engineer on the building board. Been on the building board for about over 12 years now in that position.
All right, great.
And then the other thing that we would also like to request is Mr. Notzinger is sitting there in the front row, and he wrote up that quite extensive write-up regarding the state of Alaska's law. And if there were any questions, I don't know if that was submitted to you regarding some of the implications of that simple couple paragraphs that you guys adopted on the floor of the night, and just a hint of the impacts that what may seem like a common sense, sure, let's go ahead and do this, and what happens with that. The other purpose of what I would like to be here tonight is to provide, or this afternoon, sorry, I haven't had enough coffee, obviously. Although I've seen my clock be working 11 and 10 at night quite often. So regarding Title 23 and anything that impacts Title 23 that comes in front of you, and what goes into Title 23, so that in the future when these sort of amendments come to the floor, that you understand there's a lot more that goes into those things. And I don't know when the appropriate time to talk about that would be, but that would be one of my intentions of being here today.
Well, sometimes when you make amendments on the fly, it makes changes that are unanticipated, and then you have to come back and make an additional amendment to the amendment. And so I think that's the situation we find ourselves in right now. Do you have some information you wanted to present to the committee and introduce yourself?
Yeah, my name is Ross Notzinger. I'm the Engineering Services Manager for the MOA. Work in the Development Services Department, supervising plan review for the MOA. And I can provide just like a very basic overview of the impact of this change. That this change was, I think where the problem started was it was a change that was made on the floor of the assembly, and hence it never did go through staff, and it never did go through the building board. And so it didn't get vetted as to what, potential consequences or is this coordinated with state law or not, And I think the big thing here was like the way this amendment got worded. For one thing, it threw out the allowance for a person to build their own home, because the language that was taking out allowed new construction, and the language that was put in only refers to working on existing structures, right? So that just part of the implication. Two was the language that got put in allows an electrician allows alteration work. It allows electrical, plumbing, or mechanical alteration work. Well, alteration work is new work. When you're altering a building, you're running new circuits, you're installing new electrical devices, you're installing new plumbing fixtures, you're running new piping. Even though it's an existing building, you're performing new plumbing, mechanical, electrical work. And state law is very specific as to who can perform new work, new plumbing, mechanical, and electrical work. And basically the way it works is, for the most part, you only can perform new plumbing, mechanical, electrical work on your own residence. You can't go rent a 20,000 square foot space in the Fifth Avenue Mall and have your janitor wire the building, wire the tenant space, right? And the way this amendment works, that was put in on the floor, it would allow that.
Unintended consequences, I believe.
Yes, yeah. So it's kind of a complicated thing, and I would suggest that if the assembly, there's options for dealing with it. The simple thing, you could go back to the old language, but even the old language is somewhat problematic, and so maybe one option would be for the assembly to work with the building board and staff to come up with new language that meets everybody's objective. And it's a complicated wordsmithing thing that you probably wouldn't want to do in a venue like this.
So let me ask you this. So is the state code a little ambiguous as well? Does it need
Yes.
to be tightened up a little as well? Not
Good-
critical, but
Good luck with that, right? Because that would have to happen at the legislative level, probably, which is a beast in and of itself. Yes, the state code is very difficult to interpret. But the municipal code, fortunately, is something that we can all work with, and we can make it clear and concise and easy to understand for our industry.
great. Mr. Constant.
So there was a letter reference that said you wrote. Somebody spoke about it. This was not signed by you. Did you write this? Is that what was being implied?
No, I basically put together what I consider to be notes that I submitted to the building board to help explain the issue, because it's rather complicated when you're trying to decipher state law.
I would love at some point to see those notes, if you will. Do you understand the general concept of what the amendment was attempting?
Well, under the purpose of the amendment, it basically says revise the requirements to allow the owner of a residential building to be exempt from contractor licensing, regardless of whether they live on the property or not, for existing structures to match the licensing requirements of the state of Alaska. So it sounds like to me what the goal was to someone who owned residential property, that they could do plumbing, mechanical, electrical work on that residential property whether they lived in it or not.
So I think if you were to listen to the debate that happened, and I'm sorry, I'm trying to share the number with the person who asked us to do this amendment so he could call in. I thought we exempted electrical work and work that needed certain level of licensure. And so Clearly, we missed the mark, but I think you're generally right. The intent was to allow a residential property owner not on their home of residence to be able to complete work that they were qualified to do, right? That they were not allowed to do without an extraordinary amount. They had to get a general contractor to put up sheetrock in their own home that they don't live in, that they rent. And so there's a problem there that definitely was irrational and needed to be solved. And so if we didn't get the exemption for the electrical, meaning that the electrical still needed to go through the permitting and process to make sure it was safe, that's a mistake that we should figure out how to fix. But if we do have a conversation with the building board and you as the kind of staff in charge of helping us, we don't want to get rid of what we intended to do here. The intent being to allow somebody who owns a house to work on their own house for all the things that they possibly can that aren't going to cause major potential risks to themselves or to their tenants or other people who are involved with that building. So the idea is to streamline, not to cut people out or create multiple problems. Is that something that we can get assistance with?
Yes, I'd say yes. It's state law is ambiguous enough that it was actually decided by a Supreme Court case in terms of who can do wiring and when.
Right, and I really, if you listen to that deliberation, you'll hear we discussed electric in particular and said, no, that doesn't fit here.
Mm-hmm.
Right, I think that, go back and you'll hear it, because I know we talked about that. But other things, it was the irrationality of sheetrock. It was like, what, I can't put up my own sheetrock, I have to pay someone.
It's over a certain amount of square footage.
Yeah, like, what? Why can't I do my own house? And so that's the thing that we're trying to solve. So,
Well, and it goes bigger than that. It's even just a shower valve. You know, there's a lot of little things. As a landlord for 30 years, I can tell you there's a lot of things that are just basic maintenance that they now say you've got to be a contractor to work on. And there was a real frustration with the building safety department on those, to where it was exhausting. You know, and part of it. And so, what is the problem? What are the ramifications? There are a lot of vacant apartment building units out there that landlords don't want to remodel because they don't want to deal with it. And so, how do we make it easier for them to get some, make it less expensive, less burdensome, and that way, at least they're getting these properties improved.
and I think the
alleviate
difference,
safety issues.
sorry to be jazzing here, but
Yeah.
the difference about like rental apartments, I think we didn't want commercial use properties, which I would consider a multi-tenant building commercial, but we were more in discussion about single and duplex and maybe triplex properties, but really just the homes that these people, the residential properties that they were working on. So I don't know that we want to go so far as to be able to say somebody who has a multi-unit building can just kind of do whatever they want, but
Well, I think if we, get together, work with the development department and the building board, I think we can find the right language, find the sweet spot, so to speak, here, and so that everybody can more or less get what they want, type of a situation.
Yeah, the difficulty you run into is every construction property has its own little nuances, doesn't it? I mean, no two are exactly alike. Even on identical buildings next door, you run into situations where I got to do something slightly different, and then there ends up being this gray. So,
Mr. Chair, could I ask a member of the public to speak?
Go ahead, Mr. Constant.
Can you unmute yourself, Mr. Couples? I believe it's *6.
Good morning, everyone. Can you hear me?
Yep.
Yes, we can.
Okay, wonderful. Sorry, I was unaware this meeting was happening until it was just brought to my attention. So I've only heard, and to be fair, the sound quality is a little muffled, so I'm having a little bit of a difficulty really, hearing the words clearly that are being spoken.
So, Rob, I have a question for you that might help.
Okay.
So,
Certainly.
just would you, for folks here, describe the property you were working on and describe the challenges you faced in getting the project moving forward that led to you to request members of the Assembly to support the couple's amendment?
Sure, that's an easy thing to do. So the property that sort of sparked this particular amendment was a house that's belonged in my family. It was built by my grandfather in 1951, and it's been in my family for 70 years. It's located at the corner of East 3rd Avenue and Hyder Street, which is 2 blocks from the Brother Francis shelter. And it had sort of steadily declined and deteriorated over a course of, 3 decades approximately. By the time that this particular house was, like I said, it was built by my grandfather. It was handed down to my dad. At the time that my dad since passed, and it's been handed down to me. Well, by the time it got to me, the neighborhood had deteriorated. The desirability of the location had been deteriorated. The house had sat vacant. It had been broken in by homeless and squatted in. It is a real disaster. I mean, it was a 100% gut job, which to hire a general contractor to perform the work would have easily exceeded $200,000, which was simply not realistic for the amount of risk, particularly at that location. And so I looked for. I have a tremendous skill set. I can do virtually all of the work necessary by myself. I have the ability to do that. I have an engineering background. I have specifically a structural background. And so when I started looking to permit the project and was told that I would be denied the opportunity to perform any work because I did not intend to make it my primary residence when the project was complete. And so, to me, with my lengthy history or the family's lengthy history with this particular property, it seemed a little ridiculous to me that I don't have the ability or the right to perform work on a family home that's been in my family for 3 generations. And so I continued to have conversations with people like Bob Dole and with other members of the municipality and members of the assembly. And when it came down to it, we kind of, based on the information and the conversations that I had, there were very remedial tasks that, as the property owner, I wasn't allowed to perform. For example, insulation, or really, it came down to any project, I believe, based on what Bob Dole told me, any project with a valued assessment of over $5,000. Well, if you've built anything in the last decade, you can't do any component of a building project for under $5,000. And so that basically takes absolutely everything off the table. I mean, it's pretty ridiculous. Now, I understand there's specific components of building a structure that require very specialized skills and training and code knowledge. And, to me, that's primarily electrical, mechanical, plumbing, which is why when I proposed this amendment that would allow a property owner to perform work on a residential property which they own, those 3 disciplines were specifically excluded from the property owner's rights, which means they would be able to still do roofing, windows, insulations, hand drywall, all of these types of activities, and all structural components to build the structure, which of course this doesn't exclude them or preclude them from the permitting process or the inspection process or any of these things that are still required under the permit, which I think is a great system, and it provides that necessary double check to ensure that the things are built to code and are and everything's done properly, and the reinforcing push should be and all that type of stuff. But in these conversations, this seemed like a very reasonable common ground that would help reduce construction costs to to the property owner and could potentially facilitate reinvestment in some of these areas that would otherwise be far too risky and far too expensive to perform work. And East 3rd Avenue is a primary example of that. So these are the things that the obstacles that I encountered. Ultimately, I ended up getting an exemption, which allowed me to perform all of the work, with the exception of electrical, mechanical, and plumbing. The project went very smoothly. The total construction cost was less than half of what it would have been had I had to hire someone to perform all of the tasks. And that project was completed in February of this year. It's been occupied and generating revenue, and it's a beautiful, vibrant addition to the community, like it once was. So this is why I think that this particular amendment was so important to help facilitate people like me with the skills and the desire to make these reinvestments and to improve these properties, while still requiring the most critical and knowledge-intense components of building a property. Leave those to the licensed, registered professionals.
All right, thank you.
So that's if that's kind of a good enough summary. I don't want to take up more time than I need to, but
Thanks, Rob. So for everyone here, then, that's the gist, the goal. And so if we miss the mark, then the project is to help us meet that goal while fixing what we may have incidentally broken. Does that make sense? Okay. So I don't think we're really prepared to proceed any further down this road today until such time as we've kind of figured out a work plan. But
I've got Mr. Gates in the queue right now. We'll see what he has to say. Mr. Gates?
Yes, thank you, Mr. Chair. Mr. Constance's last statement makes a whole lot of sense to me. Not ready to actually do something right now today, but definitely work needs to be done to remedy the concerns that were expressed. I asked to speak to just 2 points. One is it's very true that at assembly meetings, assembly members can make amendments, and that does happen sometimes with unintended consequences. I helped draft or put this into proper form that night, February 15th, I think, at that assembly meeting. A lot of times, though, there's, for the attorney's work, technical legal review and substantive legal review. And in that sort of quick time frame under the technical part, it's all informed, it's properly formatted, it indicates correctly what's being changed in this law that's being passed. So that's the technical draft report. Substantive reviews not very often not possible in that short form in that time frame. But fortunately, these are living documents, right? And we have experts who tell us we got something wrong and we can make changes. And so we're in that process now. And that's why I think the process works. Although we break something, and maybe short of iteration, when you have experts like the building board to bring forth those concerns. Now, I'd also say Tab 23, it's got a very lengthy review process for updating it, where we have various committees advising the building official how to update Tab 23s every 5 years or so. And floor amendments don't go through that process. So anyways, that's the second thing I wanted to say is the building board's letter mentioned 2 points. One is some unintended hazardous results, and that's sort of like the policy question. How far we want an exception to go in terms of the risks that might be allowed. But the second part of it, and that's the policy question, the second part that they said is it violates state law. That's the legal question. I had 3, 4, I think, some members asked me immediately if they were correct in the letter where they said it violates state law, and this is state law preemption question. And I promised to do some research to get back. I have not completed that. This is a legal analysis that doesn't happen very immediately, quickly. I've researched Title 23 and preemption questions in the past, so I think I can say today, which I said before, they're probably right. But I think we want an independent legal review, which I'm going to produce. I guess aside from that, the state law, as some people have said, can be ambiguous. So how far can our exemptions go with that ambiguity and not be preempted is a good question. And I'm trying to address it. Anyways, that's all I wanted to say for now. They'll probably why there's a problem here in terms of state law preemption and how to fix things.
And so, is your intention then to review that the state law with the amendment and come up with potential changes?
No, my intent is memorandum saying if the amendment here, the exception that was created by the amendment, does violate state law or not. So that's the legal preemption question. And then the fix, I think, is not. The fix is we need to undo it, but exactly how and give it effect to the exception that was drafted. For example, I think that some language could be added that limits the dollar amount of this exception for the project, and that was out. Or the scope of the project, the renovations being done. The word alteration being in here, like Mr. Robson mentioned, very interesting because the language is deleted use of the word alteration section, but it's qualified by some type of word alteration. So, there's a lot of things to do. So, can I provide a fix to move it? But I didn't tell them if the current amendment violates state law or not, the preemption by state law. I have done some research. I looked up the case law, decided, I read it, and its applicability. I obtained the state fire marshal's deferral to municipality for our own building regulation in our jurisdiction. So, there's a little bit.
All right. Okay, so the plan going forward is we'll set up a meeting and try to create a work committee to make some suggested changes. Does that sound like a reasonable idea?
Can I make one suggestion? Sorry, again, Craig Ferdine from the building board. Knowing how slow this process takes, and I hope at least our letter kind of sinks in on the potential life safety issues that are being installed in our commercial buildings right now by unqualified individuals. May I make a recommendation that the Assembly move forward with an ordinance change to go back to the original verbiage so that we can at least get back to a level of safety, understanding that people have the methodologies of submitting alternate means and methods for code stuff. If you want to do something that's not per code or per the ordinances, you can always submit to the building department an alternate means and methods to go ahead and be able to do that work if it's reasonable to the community. But then, yes, we would love as a building board to be able to work with you and find that correct verbiage. And I 100% agree with you that there is a line of common sense and a line of where we are right now and help us work together to find that best balance. But that's going to take weeks. We spent weeks working on that original ordinance, several meetings, months in fact, I think. So if we can go back to the original verbiage, patch up the life safety holes that are currently in place, and then immediately start the work to get it better, that would be what I would recommend to the Assembly.
Okay. Mr. Gates?
Yeah, thank you. I just see Mr. Ferguson wouldn't respond. There's, I guess, a few ways to go about it is do work first and make a change, or revoke this right back to undo the amendment back to the original language for the state exception quickly, and then in the longer term work on language that gave effect to the intent of this exception that's adopted. And it's easy to undo this. The language is in front of us. So I guess my question is, what's the approach? I can't do this in Assemblyman last one too, but has the building department or building board asked the Department of Law and sort of decide to work on this and say, well, that look at that work. But I don't know if you can answer that right now.
Well, I think to address Mr. Ferdine's concern, the building department has basically created a policy that says that we're going to follow state law, right? As a minimum, we're going to follow state law. So I think we pretty much plugged a hole in the possibility of unqualified people doing wiring and plumbing work where they shouldn't be in the interim. So,
Okay. Well, I think what plan of action might be then would be to have Mr. Gates put an amendment together to undo the amendment that we had done in February and get us back to where we were originally. And then once we get to that point, then we can work together with the building board and the planning department and some, maybe a subcommittee of this group and come up with some potential language changes. How does that sound like a plan of action? Ross?
So through this meeting, I've seen some of the problems with our existing language, though, and I think I can work with Mr. Gates to maybe even do a double thing where we can fix one of the problems with the existing language that cleared up the issue on this gentleman working on that home. And to meet the intent of this amendment, in addition to kind of restoring, I guess, the intent of the old language.
Okay.
My question is, can we do it all in one shot? Because practically speaking, we can't just revert back without 4 weeks of time. And so can we just land it instead of go backwards and then start over and then have another ordinance that might come 6 months later in the building season? Because if you've already plugged the hole, we're going to follow state law, then the harm doesn't sound like it's real. It sounds like it's conjectural.
I think we can. I mean, I'm willing to work with whoever, Mr. Gates, to help produce the language that solves the problem. So,
And I'm happy to take that on.
Well, we could try the one-shot approach. It would take a little longer. I think that just need to acknowledge there's some litigation risk there. While they have a policy in place to fill the gap, someone who thinks that they don't have to follow the policy might proceed, and then you have, because what we have in our code, which is also law, right? And so, which is controlling the policy or code that says the exceptions broader than the policy. And there's a litigation risk there. I mean, if I would recommend, refer up to me, is to put this change and doing the amendment on the addendum for the next meeting and get it done quick and take a little more time to do the fix. But that's just because I'm, as an attorney, rather risk-averse.
But they still have to get a permit to do this work. And so the building official is not going to issue a permit for work that they find is not legal. And so I don't know that there's actual risk there. I think it's conjectural, but I could be wrong.
Correct. I mean, we check licensing when people apply for permits. So, we check to make sure that appropriately licensed electrical contractors doing the electrical work and whatnot. And then you always have the risk of people doing work without permits, but I mean, that's irrelevant to the discussion today.
Well, I know of a story recently where an unlicensed general contractor was granted permits to do all of this work by saying he had a license. Anyhow, so there are lots of holes and potentials there, but so I don't know. Frankly, I guess it doesn't really matter. I don't think it's that complex of a question to solve this problem that it's going to take months. But if we put it on the back burner as a project that we're going to get to, it is going to take months because that's inevitably how it works. And so I like having it attached to the pressure of getting it right so that it gets done.
Well, I think Mr. Gates' idea about getting an amendment on the addendum for our meeting on the 13th is fine with me, and that way we'll be certain to be back to where we in the sort of a safe zone, and that'll give us some time to get what we hope will be the correct language the next time. Yes, sir.
Dan Benoit with the building board, but does it create more of putting the enforcement side of in the interim before the language can be revised to go through for the inspectors of having to come in, and even if someone does, that the building owner comes in and actually applies for a permit, and then it escalates into specialty contractors and the such, and then a cease and desist has to be issued, and then, then it starts this huge process of where, if it was back in the old language, then outside of maintenance and repair, the person wouldn't be issued the permit in general for the commercial properties.
Interesting.
Practically speaking, it doesn't really matter. It sounds like we're going to go with the reversion, but Rob, my experience tells me your amendment is dead and nothing will happen. And so unless there's another change that has some other opportunity, this will not come back. So that's my experience telling me that's what's going to happen.
Well, what's the committee's recommendation? Are we recommending that Mr. Gates put an amendment together for get it on the addendum for our meeting on the 13th? Correct the mistaken language that we amended in February?
My suggestion.
Mr. Cross?
I'd feel comfortable with that. I realize the hypothetical of these situations that are outliers, but I don't know if repealing it completely or anything is going to. I guess speaking to what Chris says here, I would concur. I don't know if a lot of what I think a lot of what we're considering is conjecture. So I would rather get something on for the 13th. What are your thoughts, Chris?
Yeah. Again, I think it kills the amendment because the will not come back to do an ordinance to do this. And so I like having it tied to an action that has to happen, which is a correction of the error. But frankly, I'm not going to push that hard. I've seen it been around long enough to know what this means. It just means that
well, we can keep
people-
it on
people who own
on
their-
our agenda and make sure that it happens. Excuse me. Is there any objection from any members of the committee to have Mr. Yates write up the amendment for our meeting on the 13th?
No, I do want to speak to this real quick. And one thing they say on this, he says, I think it's on third page. Hold on. Starting on 2, going over, it says the previous exemptions provided a means for owners to perform any work themselves on a property they own without any training in the relevant trade, but limited to residential properties they reside in. However, the new exceptions remove the requirement that an owner reside in the property which allows the owner to perform work in a rental units on commercial buildings. For example, under the new exceptions, a tenant or owner of a 20,000 square foot tenant space in a commercial building could have their untrained or unlicensed employees require the space because it is considered alteration. So I'm reading this. It says the owners of a commercial property and employees may perform maintenance and repair alteration work, excluding electrical, mechanical, plumbing work that requires permit in accordance with this code on said structure. So I guess the way I'm reading that, and I guess that's where we go into a work session, is I think the way it's written contradicts what their interpretation of it is.
Agreed.
So commercial is anything that's triplex or larger. The only thing that's residential in this town, as far as I've understood it, was single family and duplex. So commercial, triplex, and larger then means that they're excluding electrical, mechanical, plumbing work that requires. So, I don't necessarily agree with their hypothesis here, but we can discuss that in deeper detail later.
Mr. Chris Schutte.
Just a quick point of information, Mr. Cross. The section at the top of page 2 in brackets is what was deleted. So it's no longer in place. The section you just quoted about plumbing and electrical. So that's the old code language that was removed.
That was the old code language that was removed. All right. So then we're going back to bottom page 1B. An owner or tenant of a commercial property who uses the owner or tenant's own employees to do maintenance, repair, and alteration work on the property would be an exemption. Using their own employees to do maintenance and repair. All right, yeah, okay, now I see what you're talking about. It does create an issue. All right, thank you.
I thought we had left out that section, left in the section excluding electrical, mechanical, and plumbing. That was just an oversight.
Yeah, I would almost like to have left section C in there. That section C of the deleted, the owners of a commercial building and their employees may perform maintenance, repair, or alteration excluding electrical, mechanical, or plumbing, particularly with larger commercial properties. Then we're talking, larger electrical panels and three-phase electric. I don't want a guy using his handyman working on a three-phase panel. Thank you.
All right, thank you, Mr. Cross. Well,
What is
are
the
there
order
any
about?
objections from members of the committee?
Untitled what?
Somebody on the phone? Not hearing any objections, we'll have Mr. Gates put an amendment together to undo what we did, and then we can work with the building board and the planning department and see if we can get some improvements into that language so that we're in line with state law and also hopefully doing what we were intending to do and try to allow people to work on their own buildings. Okay, well, our time for our schedule is about half up, and so let's go to the next item on our agenda. The discussion of the AIM 151-2022, the renewal status of some marijuana licenses.
So because they were online there. Mr. Chair, I can kind of go over the AIM and then what we're going to discuss for future. So the AIM 151-2022 was submitted to the Assembly at the August 23rd meeting. It was an update to the Assembly about the current status of the renewal applications for the marijuana establishments. And what was noted was there was 4 licenses, 5 originally. The Assembly bifurcated 1 off and did a laid on the table AR at that meeting to approve continued operation for that establishment because it was a first-time renewal and they hadn't had any prior renewals, so they didn't have any prior late submissions. The other 4 we looked into, and there had been previous late renewal applications submitted for the other 4. So this AIM, along with proposed action for those 4 licenses, was referred to CEDC. So on the screen is one of the proposed Assembly resolutions that's going to be before the body at the special Assembly meeting after this committee meeting at City Hall. This is for Alaska Marijuana Gardens and AMG Concentrates. It's the same owner with 2 licenses. And the proposed resolution is allowing continued operation of these 2 facility licenses under their current license until their renewals are issued. So the proposed resolution is basically lumping these 2 licenses in with the previous licenses that fell under Anchorage Municipal Code, allowing for continued operation of timely renewals. If establishments submit a renewal before June 30th, it's considered timely, and per AMC 1080, they are allowed to continue operating until the completion of the review process and issuance of the renewal license. If it's issued after June 30th, so July 1st or up to August 31st, it's considered untimely, and they would fall under the provision of cease operation until issuance of their license. So these 2, and then this is the second AR you'll see, and it's for Arctic Earth and the Green Room AK. proposes for these 4 establishments to be able to continue operating until their renewals are issued. There are 2 ARs because Arctic Earth and Green Room, upon review, we received no protests from any of the reviewing agencies, so they are complete pending receipt of a deemed complete state renewal application. The other, and so you'll see we did our review. This is kind of your standard language that you see in all of your marijuana ARs of the review findings, and so everything is accounted for. In Alaska Marijuana Gardens, they were found to owe taxes, fees, or fines. And so you can see there is a separate finding that they're still owed. And then section 1, we have a conditionally approved until payment in full. And then also similarly, we're waiting on the deemed complete state renewal application for this one as well. So both are proposing allowed continued operation. We did have some information from the licensee, and I know she's called in, so she'll be able to add some information to that for Alaska Marijuana Gardens owing. They have some legal issues going on, and so they're dealing with that currently. They've been in contact with the finance department, so they are working on it, but it has not been paid as of yet. So that's kind of the status of these 2. And the proposal for this meeting and having the AIM referred was to discuss the 2 proposed ARs that'll be before you at the special meeting, and if you have any floor amendments that you would like, if you want to change anything in these 2 ARs. And then a bigger discussion, the process surrounding the late untimely renewals, and moving forward into future renewal years. So recommendations from the committee of that.
Okay. Thank you, Ms. Ahmed. Well, you know, and we've had this new and continuing to develop industry here over the last 5 or 6 years, and you know, the license renewal process, since it doesn't fall on the end of the year, it, you know, somehow might slip through the cracks, and some of these businesses didn't get a renewal application in on time. So we have to make a decision as to whether we want to allow them to continue their operations, or whether we want to suspend their license and they have to stop their operations until they get the permit renewed. Mr. Cross.
So is this a question about just is the process too convoluted that we've created? Because I will tell you, I'm not familiar that we extend this benefit to other businesses. I can tell you that if you don't renew your real estate license by January 31st of even numbered years, they will immediately shut you down. No matter what you have going, you have to transfer all your work to your brokerage, and you have to wait for them to reinstate your license. There's heavy fees, and it may take them 6 to 8 weeks to do it, and you can't get paid on anything. So I know that there's other industries where if you don't meet that guideline, there's not a grace period. So, but I'm not opposed to this. I just want to understand, is this because we created a difficulty in the situation, and that when we put this together, because it's a new industry, that, you know, we're just figuring it out? Under what circumstances are we providing graces that other businesses may not get to go?
Well, and there's a complicating factor in the state. It also has a licensing process, and so they may be applying for a state license, and that may come at a time after we have already taken up their renewal, so that creates another level of potential confusion there.
Yeah, and I admittedly don't know enough about that licensing process for the marijuana shops that perhaps Janet can speak to this about those complications that the business owners would have, that we can remedy this to make it easy to do business. Chris?
Yeah, first, to your first question, is it so complex? we had 102 licenses that were done timely and 5 that were not. So, there's ample evidence that licensees can comply. It's not just an overburdensome process. So that's one factor. Plus, of the 5, which there's really just 3 operators, one, it was first time mistake, and so there was some grace applied. The second 2, this is their second time, I think, or more. And so it certainly raised the question of what should we be doing here in the context of discipline and order. The real estate license one is somewhat different. This is a municipal license, not a state license. And I think that there are some ramifications of the suspension of one of these licenses that, unless you're a broker and you have all kinds of people working under you, and the broker lost their license and somehow everyone was cast out, that would be a more parable situation where this scenario doesn't just implicate one person and their finances, it implicates all of the people that they work for, all of their suppliers, all their operations, etc. And so it's a complex question for us to contemplate. And but what we haven't done is establish a, if you will, schedule of penalties, right? So we're operating in a place where we have to be careful not to be arbitrary with our decision-making processes. We should be thoughtful about our approach and make sure that the penalties are in scope and scale with the violation, and not because if we were to shut down, not license these until say the 13th of September, probably one or more of these businesses will be dead because the margins are thin and their operations are slim. And in my head, I have, in some ways, because we've been through this before on a different context with the licensee that was failing to live up to the standards of their license. But they were doing things that were really egregious, that were harmful to the safety of the public. There were, materials that contained marijuana in dumpsters that were being accessed by people who are dumpster divers, illegal diversion, like potential harms to the community, as opposed to, I missed the deadline, right? Which is, on the scale for me, not so significant, but significant enough that we need to talk it through. And so, for my part, what I hope to get out of this conversation is a reasonable decision about what we should do with these licenses and to establish a precedent going forward so all the industry knows going forward, if you miss these deadlines, these are the things that are going to happen.
So then what happens is you might have, here's a deadline for your filing, and then a punitive phase. And if you go beyond that, you can still operate for another 45 days, but maybe there's a significant daily prorated fee in order to light a fire.
So we can't charge fees. So the number one penalty that we have is, and are the operators here, the licensees? 1, 2. So are you operating today?
We are. I am from My name's Ivy from Cannabis, and we're the one that we're given some leniency.
Right, because of your first operation. Are you operating today?
Yes.
No.
You are, but no, you aren't. Sir, what's your name again?
Adam Ferguson. We were told not to after midnight.
With
the Green Room AK and Arctic Earth.
and the person on the phone, are you operating right now?
Can I speak?
Yes, please.
Okay, yes. Yes, we are operating.
So
Hello? Yeah.
you should not be operating today because I don't believe you have a license.
Sorry, hold on. Maybe I speak myself wrong. Like, I am inside of my building taking care of my plants, but I'm not selling out to the public.
Yeah, okay. So if I might, is your operation, do you have a license for retail and for cultivation or just cultivation?
No, I have a cultivation and a lab. I'm manufacturing.
Okay, good. So in the case previously when we had cultivators who got in trouble, we let them continue to maintain their crops, so we didn't kill their crops while they were shut. But I assume you're not selling to any retailers today.
No retail for me. No, I'm not selling. I'm not using my metric.
Right, okay. So the penalty that we have applied today is they cannot conduct their business, right? And not as a penalty that we have. We could say they cannot conduct business until we have a special meeting today and fix this mistake that they made for them, or we could say you have to wait until the 13th when we have our next regular meeting and get it on the agenda, or we could say, and I've had some calls from members of the industry who are concerned about the competitive nature of the industry right now and wouldn't mind having fewer competitors in the industry, who said for this deadline missing, we should just not let them renew their license and make them go back through a renewal process and a reapplication process, which could take 6 months. And that would mean those businesses are doomed. And so we are here, in my opinion, to figure out a balanced, thoughtful remedy to the mistake that these applicants have made.
And so we can make a decision to let them, allow them to continue. We can suspend it till the 13th. We can suspend it for a week. We can do whatever we decide to do.
The assembly can. We can
Assembly,
recommend.
right.
I got it.
And so that's the decision process that we're in the middle of right now, and then it carries on to the special assembly meeting. It starts at 1 this afternoon.
And so if we might, I would like to ask each of these licensees to take just 3 minutes to tell us, well, what happened, how did we get here, and what's going to happen to your business. But 3 minutes only, because we have a special meeting at 1 and we have to get through this business here.
No, I agree.
Okay, so any of the licensees, who wants to go first? Sir,
I can do.
introduce yourself.
I'm Adam Ferguson.
Could you come forward so that we can really hear you on the recording? Thank you.
And close to that phone.
Yeah, I'm Adam Ferguson. My wife and I own the Green Room AK and Arctic Earth. We do it on our own. We don't have any investors. I'm a full-time electrician on top of that. Yeah, we accidentally turned in the city application with the state one, and apparently the state hasn't really looked at it because they didn't send it over to the clerk. And so then we got it in as quick as we could. I did it the first 2 years, and we were on time those 2 years. And then, yeah, we were trying to be on time this year too. But and then, yeah, like today we'll lose $3,000 because that's our daily on our store currently, which only half of that is profit because half of it goes to product. And yeah, I mean, if we had to go a week, we might not be able to reopen. So, like, I still have to be an electrician to support the marijuana business. So,
Thank you.
Yeah, okay. Thank you. Yeah.
So we have had the extension. This is our second year in operation. Our first year, we had an attorney that we hired who did all of the paperwork for us. And this time around, we sent in the state application at the beginning of May, and we just thought we had everything done, and we didn't. And when Ms. Thomas let us know, we turned it in that day, although it was already delinquent. And it will not be late again.
Okay. And on the phone?
Yes, my name is Evangelina. I had two partners at the beginning of the business. First year we started in September. That was on the 2020. Then I didn't do the paperwork. Last year I paid a lawyer because I want everything to be on time, and the lawyer forgot to turn the documents on time. I paid the penalties for the late submission. This year, I did the same mistake than Adam at the Green Room. I submitted my papers because I was doing it in person because I wanted to do it on time. I cannot trust the lawyers. And I submitted to the wrong place. Mandy helped me out there to figure out where my documents were and to submit it to the right place. I'm very sorry. It's my first time submitting this document. And yes, I already was punished and penalized with my license being suspended for 20 days because I get a disciplinary action because I was late on my taxes. Late on my taxes because the persons that I sell the product don't pay me on time. And it's my choice, as I understand, that I choose to sell to the people, giving them some time to pay me back and sell the product. But I already got punished once. I almost got shut down. I cannot afford to provide for my employees without being able to sell. And the last time also, when the metric was canceled, so many stores got damaged because of the license action against myself, and they were not able to sell the product or to use the metric. And we figure out that, not we, metric and whoever was in charge of this, it took them about 8 days to figure out that problem. So many people was in trouble because of the disciplinary action that they put against my license. Then I don't think we can afford to get that problem going away again to all the industry. It's not punishing me. It's punishing a lot of people because they don't know how to do those things. They don't know how to control the metric just for one person. Then please, mercy on us. It's an innocent mistake. I apologize so many times, and I've been sending emails everywhere because it was my mistake, and I dropped the document on the 28th on the wrong office.
All right, thank you.
I would like to get them back in business as quickly as possible. I understand the frustration with filing documents to the wrong department. I've done that before.
So, what I had initially thought was, separate from these two licensees, we ought to contemplate what a fair penalty is going forward. But because we didn't have a standard set up, I don't know that it's fair to apply that standard to people today. And so I would, recognizing that there are people out there who will be mad if we do this because they made a mistake and they're behind and everyone else got it right, then in my mind, again, I sort them out into bureaucracy and paperwork versus harms to the community, very different penalties. And I would agree with you that we should make a proposal to the Assembly to authorize these resolutions to let them get back into business.
Yeah, and we should make it easier to streamline paperwork. I agree the frustration with multiple different entities that you need to send duplicates or similar paperwork to. That's very frustrating. It'd be really nice if there was one pipeline and one source. From municipality, we forward it on to the state or whatever it is because, I just think it should not be so difficult to provide jobs and have a business. We should simplify it as much as simple as we can.
And that comes to my next proposal.
The state AMCO board meets quarterly, I believe, and so that sort of creates a problem as well, because they're not meeting monthly or bi-monthly or anything. Ms. Welsing, do you have any comments you'd like to make?
Yeah, I have just a few thoughts. I don't represent anybody on Exhibit B, but I think, for the industry members that maybe are feeling like, we don't need to give any leeway to these folks, I would remind them last year there was I think there was more people on Exhibit B. And it sounds like everybody here kind of like did take their best efforts. I would say that the Muni renewal process is super simple. Manny makes it really streamlined, and we submit things to Manny, and it's really easy. But what I think kind of complicates things, especially for the retail folks, is the renewal too of the registration of the tax registration. That kind of happens on top of this with different times. It's like a September 15th deadline or something like that. I can't remember exactly. So that's on top of this state and on top of the Muni. There's also this other retail component for the tax registration that comes up. So that's another complicating factor. I would say it sounds like all of the guys on Exhibit B submitted their renewal before August 31st. That's correct, right? So I would say if you wanted to put something that's more punitive, it would be renewals after August 31st. Then that's like the drop dead date. Sorry guys, you really messed up and you're just like done, or some other kind of process. For these guys, it's hard because your renewal deadline is not the state's renewal deadline. So your renewal deadline is June 31st, and the state's is July 30th or 31st or something like that. And it's just two different things. And then there's a grace period where you can pay a late fee to the state. You can implement that. You know, you could file a renewal with the state up to August 31st and pay a $1,000 late fee. So you could implement something like that. I think you could do that in your code a month. You can't implement any fees?
We might be able to, but I thought that we were told that we were limited on the fees, that the state charges the fees and we get a portion of that.
I think that's one.
You get a portion of the review fee. You do not get a portion of the actual
Okay, so we
license.
should explore that as well.
But I do think, to her point, and enforcement is here to speak to it also if you have questions, but there's been discussions of previously of trying to add some sort of fees to the fee schedule for certain infractions.
And so that's all I would say is just there is these layers on layers, and I understand the industry's frustration about giving leeway to folks, but I mean, again, this list was bigger last year, so I mean, everybody has learning experiences.
Okay, so I would
Thank you.
make
Mr.
a.
Johnston?
Are you still there, Mr. Rivera?
I am, yes.
So we have a quorum. I would make a motion that we recommend to the Assembly special meeting today at 1 o'clock to approve these. And Randy. Thank you, Mr. Salt, that we approve these resolutions.
Is there a second?
I'll second that motion. Second.
Okay, made by Mr. Constant, seconded by Mr. Sold. And
So, yes.
Mr. Sold has joined us evidently half hour, 45 minutes ago.
11:05.
At 11:05, okay, great. And so, are there any members of the committee against this? If not, then I guess the committee has recommended that we allow some grace for these businesses at our meeting this afternoon. That'll be the committee's recommendation unless I hear something different in the next few minutes here.
And separately then, assuming that that's now the facts, Mr. Chair.
Mr. Constant?
The one thing that we have, I guess, talked about and we should get to is a conversation about fees and penalties, because we've never created any kind of a tool for members of the industry and the public to know what are the penalties for certain actions. And so it's really hard to be in this position and try to apply order and discipline without having it thought through. What is the response? Like, you know how much it costs if you're going X over the speed limit because it's published at the state, you know, and so we don't have anything like that. And I think it would be wise for us to spend some time doing that. And then separately, again, I have that additional item on the agenda that I would like to talk about. And that is one of the problems that I think we're facing now is we have an industry that is, you know, some 98% in compliance, which is the basic stuff, really doing a good job. There are still issues of smell and other issues that we are continuously going to struggle with. But for the most part, the industry's done a good job. So the question that I have, and I'm working now on a project to do, is shift us from an every year application to once every 2 years.
I agree with that.
So that these businesses don't have to keep chasing the same paper over and over again, each time becoming an opportunity to make a mistake, and just wasted time and money. And our staff, who have to run around managing all this paper when we now know that the industry is, after some 7 years, doing a fine job. And so I just wanted to put that out there and ask who wants to work on that project with me. And okay, Mr. Cross. So that's happening, and Mr. Gates is reviewing the law now to figure out what the subtleties of the questions are. It turns out that we would still have an annual opportunity to protest the license at the state, even if it were outside of the cycle of our license. But because we are a licensing entity, it doesn't matter. We can always bring a license back before us if they're failing to operate. And so that opportunity to protest it exists, but it's not really something we've ever had to or would likely need to exert because we are the licensing entity. It's a dual license. So that's a project that I'm hoping to get it moving forward in the short order so that by this licensing year coming up, everyone gets a break.
Well, another thing I think you should take a look at is seeing if we have to change our renewal date so it matches the state's to just to make anything that makes it less confusing and to help the businesses to, they know, okay, everything is going to be due on July 1st or July 30th or whatever it is, then they can get those applications in a timely manner.
So my question to Jana would be, is that possible, right? Because, or to Mandy, because the state licensing process, doesn't it rely on our process as well? And so if we must deem it complete for them to finalize their project. So I think there's a process.
I'm sorry.
Go ahead.
You get 60 days to protest it. And I need to check the regulations to look at the exact dates, because there's like the date of when the renewals open and you can file it, and then there's the date of when you have to pay a late fee. And so I can do an email to Mandy kind of outlining that with the state statute. That would be helpful, and then go from there.
And the other part, though, that we know we can do is line up the renewal process with the tax licensing process for the retailers, so that it actually gets wrapped into the same application process, so that by the time all of that application is done, they've done it all, and it's in one shot.
That makes sense. It's just they need the information in order to do their job. So, okay.
Right. I mean, having to come up with 3 separate applications does seem to make it a little more complicated than it really should have to be, I would imagine.
And risky if they're making a mistake.
Right. Okay.
Let's do it. Make it better.
And so we'll continue moving forward with the idea of looking at shifting to a 2-year cycle for license renewal, and try to talk about making some additional changes to the language.
You know,
however we can make it
streamlining.
One thing I forgot to mention.
More simple.
I have been in discussion with the AMCO staff, and they are working on a project to discuss with the legislature making the state licensing biennial. And so my hope is that our work doesn't just accomplish our goal of streamlining, but it also incentivizes the state legislature to follow us. So it's multiple levels of attempting to streamline.
Yeah, if they see that we've done something that seems to be effective, they may want to adopt it and then make it easier, less confusing for everyone involved.
And then Mandy will have more time to do other important work.
There's always lots of things to do in the clerk's office. Okay, any other discussion on this particular subject? If not, we'll move on to any other ongoing business, and I don't know of any ongoing business right now. Or no old business that I can think of. Is there anyone in the audience that would like to participate? If you need to participate, you get 3 minutes. If you're on the phone, to unmute, it's *6. And so if you're on the phone, unmute and introduce yourself, and you have 3 minutes to comment.
Okay, is that for me?
Excuse me?
Is that me, the one that could speak over the phone?
Okay, go ahead and speak up.
Okay, I just want to say again that we were punished one time and we lost business for 1 whole month. Then the coming month for taxes, how much did I pay to the state? 0. Because for 1 month almost, I was punished as not being operating, and I was able to sell nothing. Then the state missed between $60,000 and $80,000 on I pay on taxes. And that's for not just me, everybody. If you do this to all the other businesses, just see it as a business. How much money is the state going to miss from shutting us down? And also, how many people is going to go to unemployment? Give us the opportunity to work. And we know we make the mistakes, like the people over there is saying. Just make a rule. If you do this, this is going to be the penalty. Don't give us another penalty on top of the penalties that we already have it of not selling, and the state of not getting revenue from us. Put something on writing, say this will be the fee. Sorry for us, and sorry for all the ones that are mad. We didn't do it on purpose. Of course not. We submitted documents because we want to be on time with everything and on compliance. We did a mistake, and we're human. Put out paperwork and says, next time that you make a mistake, this is how much you're going to pay. But don't punish us much more. We already are punished. We've missed money, the state missed money, and we have to keep paying those employees. And if we don't pay the employees, they're going to go to unemployment. Then who is going to pay for that? Give us the opportunity. Forgive us for this time. I'm very sorry. We all are very sorry. That's all that I can say, and thank you. And please, help us.
Okay, thank you. Anyone else online or in person that would like to be involved with audience participation? Not seeing or hearing anyone. Mr. Constant.
Yeah, I want to remind everybody who's on the phone, members, and in the room that we do have a special meeting in 40 minutes at City Hall in room 155 to take this matter up.
Thank you, Mr. Constant. I was just going to mention that.
Sorry.
If there's no other comments, I'll accept the motion to adjourn.
So moved.
Thank you. We are adjourned.